I'm Jason Susser. As Ian said, a U.S. immigration attorney, focused mostly working with entrepreneurs and startups. Here's a short bio about me that basically says the exact same thing. I work with lots of foreign entrepreneurs, often helping them with their own immigration process. And then I have the good fortune to get to work with a lot of their companies as they grow, help them develop immigration policies, help them onboard early employees, help recruit talent. I recently co-authored a book called Immigration for Startups, a guide for founders, with my colleague Greg Siskind. So that's exciting. We're going to, at the end, set up a way that you can contact me, and the first 50 people interested will send a copy of the book, so can learn more about this field. And then briefly, who we are, Siskind Susser. The firm was founded in 1994. It was sort of born based out of technology. It was the first immigration law firm website in the world. We had the first legal blog in the world. So visalaw.com was founded by Greg with sort of the coming of the internet. And we've continued to embrace technology since then. We have our own tech company, visalaw.ai, where we build immigration software for other attorneys and for clients. Yeah, so I think that's enough about that. So quick overview. I don't want to lecture the whole time or just talk the whole time. I'm sure people have questions. Hopefully not every question is how does the election affect my personal situation. Although I would imagine no matter who wins the presidential election, it will affect your immigration journey and my daily life. But we can sort of get there. I thought I would spend about 10 minutes speaking mostly about F1s, and then 10 minutes or so on H-1Bs, and about 10 minutes on O's. And then if I have a little bit of time left, I was going to discuss briefly e-visas. There are other visa options out there. These are the ones that I just think you should probably, most of you are either experiencing now or should be considering. And there's just not enough time to talk about green cards and all of that today, so we'll have to do that another day. So I would say that, I don't know the percentage, but a large percentage of my clients start out as F1 students. A lot of them are MBAs, and they are trying to figure out while they're studying at what point can they start their company. So many of my consultations start with, I'm graduating in 6 months and I want to incorporate now. Can I do that? And so the thing I try to point out to everyone is that the rules that you need to be thinking about, the laws you need to be thinking about, are about work authorization. They are not about incorporation, right? So the focus is on work. It is not on equity. You can be an F1 studying at a university in the US and own equity in all sorts of companies. The question is, are you working for those companies, right? And at the time you are working for those companies or company, you need work authorization. So the real crux of the issue is, what is work? And unfortunately, it is not defined in the immigration law. So early on, if you're an F1 and you're still studying and you don't have work authorization, and you are looking to incorporate, start a company, work on an idea, any of that, I think you need to look at each of the tasks or duties you are considering and figure out whether or not you need work authorization to do those things. So we do know, we have some clues about things that require work authorization and things that don't require work authorization. So attending business meetings, negotiating contracts, attending sales meetings, training, conferences, seminars, those are all things that do not require work authorization in the US. We know that because the Department of State says visitors can do that on visitor visas that do not give them work authorization. We also know that some things that are not permissible. So supervising staff, providing services directly to a U.S. company, which is a pretty vague one, representing the company, making decisions that affect U.S. operations. And then I think those are all sort of vague and not extremely helpful. The last one is what I think of as sort of the golden rule in making these determinations. And it's any activity that a U.S. worker would typically be paid to perform. So I sort of try to think about that. It's like, if a U.S. worker were doing what you are doing right now, would he or she be paid for that work? If it's meeting with co-founders to discuss an idea and whether or not that could be a company, probably not, right? I mean, no one gets paid to have those conversations. That's not work for anyone. But if you're sitting there coding, or developing the product, maybe, right? Like probably that is where a U.S. worker would be paid. So here are some more examples. Coming up with the idea, that's not work. Hiring providers to form the entity, so talking to lawyers, banks, anyone like that, not work. Obtaining financing. This one is sort of gray, I think. I did this panel for the American Immigration Lawyers Association from student to startup, and a number of us were on the panel, and this was one that we had a lot of talk about, but ultimately felt that negotiating contracts is permissible without work authorization. So raising funding can be too. And I mean, I have seen it done and never seen it be an issue. That doesn't mean it could never be an issue, but I do agree that is not something that necessarily requires work authorization. And then again, developing product, hiring and supervising staff, selling the product, operating the company. At that point, you've crossed the line. You need work authorization to do those things. So the question then becomes, like, how do you get work authorization, right? And so if you're an F1 student and you're still currently studying, then I'm not going to spend much time on like CPT or pre-completion OPT, but those are options. Basically while you're a student, you can do up to 20 hours of on-campus employment, or you can apply for curricular practical training, CPT, if your school allows for it, and it is, part of what you're studying. Not always a great option, though, really, for starting a company. I think the more appropriate option is probably pre-completion OPT. And the way pre-completion OPT basically works is it is part-time, so it is up to 20 hours per week, and that is taken off of the OPT you would get after you graduate. So most people get 1 year of work authorization after they graduate, called OPT. If you spend 6 months of pre-completion OPT, so 6 months of part-time work, then you would take 3 months off of the 1 year you would get post-graduation. So pre-completion can be a good option. You really need to talk to the DSO at your school to find out whether or not they allow for pre-completion or whether or not they use CPT. It really is school specific. And the universities have a lot of autonomy and authority to make those decisions for their students. So there's not going to be like a one size fits all when it comes to work authorization before graduating. Upon graduating, though, most of my clients, I would say most, start their companies on OPT. So the purpose of OPT is to gain practical experience in your field. Assuming that the company you are starting is somehow related to what you just spent all of that time studying, this seems like a good fit. Unfortunately, unlike CPT, though, OPT doesn't begin until you actually receive a work card from USCIS, which currently takes about 4 to 6 months. Over the summer, people may have heard, those got even slower. USCIS got sued by a friend of ours in Ohio, and the judge said, print the cards, duh. And so they're printing the cards again, and they're pretty much back to 4 to 6 months. With CPT, the school actually endorses you for work authorization on your I-20, so you don't have to wait for USCIS to give you a card. Once you are authorized to work, though, you can begin taking a salary, and that can include any sort of compensation, equity compensation. One thing to think about with OPT is when you graduate. So I don't want to get too far into the weeds here, but there's a thing called cap gap for people who will enter the H-1B lottery. For most people, if they graduate in the summer, then the following spring, when they apply for the H-1B lottery, they are still on OPT. And so if they're selected, their OPT is automatically extended from the summer expiration date until October 1st, when their H-1B would then start. So the gap in your work authorization is automatically filled. That doesn't always work for winter graduates, because if you graduate in December, and let's say you start your OPT in January, then the following, you could go in the lottery that March, but let's say you're not selected the first time around, the following spring, you wouldn't be eligible for cap gap because you still wouldn't be in OPT. I think I'm going to look at the questions at the end. So I will get to all the questions though. STEM extension. Okay, so for people who study in STEM fields, they are eligible for a STEM extension, assuming they haven't already used their STEM extension, and it's 24 months since it was extended in 2016. So you are permitted to operate a company, found a company while on OPT and STEM OPT. Some things to think about on STEM OPT though, are number one, you need a signatory that can sign and bind the company on its behalf, and it cannot be you. So that could be a co-founder, that could be a member of your board. It probably shouldn't be anyone more distant than that though. The reason is that with STEM, you submit a STEM training plan. It's a plan that explains basically the nexus between your degree and your position, and how the work you're going to be doing is practical training for what you studied. And it also explains how they will oversee your work, how often they will oversee your work. They're looking for things like daily check-ins, weekly meetings, quarterly reviews, things like that, to understand how you will be overseen. So you need to think about that. If you're a solo founder and the CEO of a company with no board, that's probably pretty complicated to explain, versus if you're part of a team, and maybe you're head of development or director of engineering, and the CEO, your co-founder, oversees your work. That's probably easier to explain from a STEM perspective. Again, it does say you're allowed to have alternative compensation, so that should include really anything that you would be considering. And then one other thing to note is that you do have to register for E-Verify in order to qualify as a company to support people on STEM OPT. I will say applying for a STEM extension is different than OPT. You actually do get an automatic extension of your OPT when you apply for STEM. So you're not sitting around waiting for a card. One last thing, and this is sort of I maybe should have said this at the beginning. US immigration is incredibly slow. It's always been slow. It's really slow now under the Trump administration, and has only gotten slower since 2017. So the thing about it is you should plan in advance. Do not wait till the last minute. All of these immigration tasks become infinitely harder on a shortened timeline. And so every so often there are people who wait until the last day to file their STEM extensions or their OPT requests, and inevitably something happens with the mail or FedEx, or they signed the check wrong or something, and it gets rejected, and then they want to send it the next day, and they're denied their OPT or their STEM extension. So as early as you can get your I-20 from your DSO, which is usually 90 days, you should really submit in advance, plan in advance. The H-1B lottery. So again, sort of moving from the typical path of coming up with an idea while studying, moving into OPT, forming the company, what will be next? So maybe you have a year of OPT, maybe you even have 2 years of STEM OPT after that, but still, I'd imagine you want to know what will happen 12 or 36 months down the road after forming this company and hiring people and making all sorts of obligations. And also, I assume people like Ian generally want to know where you will be in 12 or 36 months from now, having invested in your company. So again, you sort of should plan ahead. And the H-1B is one way to do that. I'm going to talk about O-1s afterwards. And again, with either of these, like one of the takeaways should be that you can lay the groundwork now for your visa later. Okay, so it's like, particularly with the O, don't wait until you need it. And that's, I mean, obviously true of the H-1B, just through the way that it works. Like you generally just can't get an H-1B when you want one. You need to get one before you need it. So assuming you're on OPT or STEM OPT and you want to transition from that to an H-1B, there are 85,000 new H-1Bs per year based on a statutory quota, an outdated one to say the least. And they become available on October 1st of each year, which is the first day of the fiscal calendar for the federal government. So as of 2019, there's an automated registration system in March where you and your employer basically are put into the lottery. This is actually a nice improvement. There was a lot of fear about it. Technology, when used by the government, can be scary. But there was one glitch, but overall it worked quite nicely. It brings down the costs of H-1Bs for employers, which is good, and really streamlined the process quite a bit. So I'm a fan. It's open from March 1st to March 20th. At the end of the month, they announce who has been randomly selected from the 85,000. Again, 20,000 first being held for U.S. master's degree holders. And then there's the second pool of everyone else. So the only way to increase your odds of getting an H-1B in the lottery is having a U.S. master's degree. At this time, there have been and there are proposals to change that, but at this time, the U.S. master's degree is the only way to increase your odds. If you are selected, then you have 90 days starting on April 1st to file your application. Again, this helps. So this helps summer master's grads, which is a sort of small group, some maybe, but it is a really nice addition. So because this new system, if you are going to have your master's degree at the time you file, then you can file in the master's cap. So in the past, everyone filed in the first week of April. Many people got their master's degrees in May, June, July. So in the first week of April, they did not hold master's degrees, so they weren't put in the master's cap. But now, because we have a 90-day filing period, we can put you in the master's cap in March, as long as you will have your degree conferred to you within 90 days of April 1. So most people who are graduating that year. And then what is an H-1B? I mean, so an H-1B is an employment-based visa for a person in a specialty occupation, which we're going to spend more time talking about. But according to the Trump administration, that means a person having at least a bachelor's degree or the equivalent experience in a specific, see it italicized because it is often litigated, specific field. There is a new rule that you may have seen floating across the internet that was released this past month and is set to go into effect in December. That would basically turn harder Trump administration views and policies into actual agency rules. and how they interpret specialty occupation, and some other things. It'll affect contractors. There is some language in there that would affect entrepreneurs, though I don't think it moves the goal line all that much. So in order to show a job is a specialty occupation, you'll note that it says 1, 2, 3, or 4 ways to do this. The Trump administration tends to read this list as 1, 2, 3, and 4 ways to do this. But I promise, if you look in the regulation, it says 4. So basically, you're trying to show that your degree is related in one of these 4 ways. So 1, is a degree the normal requirement for this job? And again, the Trump administration relies on what's called the OOH, the Occupational Outlook Handbook, which comes from the Department of Labor, even though the OOH has regularly asked them not to do that. 2nd, the employer normally requires the degree. 3rd, the duties are so specialized or complex. Or 4th, the degree is common to the industry. So a very typical example is I have a bachelor's degree in mechanical engineering. I'm going to work as a mechanical engineer. The OOH says that most mechanical engineers typically have a degree in mechanical engineering. So I've met prong 1, and so on and so forth. A less typical, harder example would be I have an MBA, and I am going to be the CEO of my new startup. Well, the OOH does not say specifically what degree is common for chief executives, so it is harder to establish prong 1. It is harder to establish prong 2 because there is no way to show the employer has required the other CEOs to have an MBA since there aren't any. It is hard to explain number 3, but it is possible to show how an MBA can handle the specialized and complex duties. And then number 4, it is probably an argument that you would need to use that is common to the industry. So pros and cons for entrepreneurs on the H-1B, mainly this first one, specialty occupation, and particularly for people with like MBAs, business degrees, even mathematics is now, according to the Trump administration, a somewhat generalized degree. They want to see like analytics or business analytics. If you're going down that route, it makes it easier. If your MBA does have a specialization, like you studied entrepreneurship specifically, or even better, something like maybe technical, like again, business analytics or something like that, that can make the H-1B specialty occupation argument a bit easier. Also, very notable, the H-1B has a wage requirement. So this also had a new rule come out early in October with no notice from the Department of Labor, and they significantly raised wages on thousands and thousands of jobs. So basically the way the wages are set, if you don't know, is you look up the job code and then you look up the county you're in, and that determines the wage in a range from 1 being entry level to 4 being managerial and senior. So the DOL rushed this rule out. They went so far as to not even calculate the new wages for a whole bunch of positions, like 18,000 plus jobs. They haven't even calculated the wages for. And they just decided everyone should earn $100 per hour for 40 hours a week for 52 weeks a year, which equals $208,000 per year. And thank you, DOL. According to them, everyone now makes $208,000 a year, which is ridiculous. And so they're being sued in federal court by a whole lot of people. We're involved with one of the lawsuits. The American Immigration Lawyers Association is involved, and a lot of other excellent firms and groups. So we hope to see some more thought put into that. But for your purpose, just think about the chief executive position in Palo Alto has a level 4 wage of $248,000+ per year. Not very bootstrap friendly if that is your goal. Couple other things, employer-employee relationship. So you must show that the company controls your employment. Under the new H-1B rule, that would be a little stricter, but basically you would want to show that the company has the ability through an outside entity to hire, fire, and control you. So That is a place where H-1Bs, I think, and immigration in general could seriously conflict with your business decisions, and is a time that maybe you, your business lawyer, your immigration lawyer should all have a talk about what that means for you and your company. If you are comfortable with that, which some people are, setting up a board of directors that can control your employment will pass muster for H-1B purposes. Next, ability to pay. So the company must show that they have the ability to support you. There's no clear guidance on what that means. What it means to me, I will tell you, is that I like to see the company has at least 1 year of the H-1B employee's salary in the bank. So if you're going to make $90K, I would want to see $90,000 plus in the bank. If you don't have that, I would want to show safes or term sheets or something to show where the money's coming from in order to overcome that issue. H-1Bs are capped at 6 years unless you start the green card process and have an approved I-140, which is part of the green card process. Once you have an approved I-140, you can get H-1B extensions forever or until you just complete the green card process. And then another thing to note is that under the Trump administration, there's a 40-something% chance of a request for more evidence when filing an H-1B, and then something like 40% of those cases are then denied. So pre-Trump, there was a single-digit denial rate on H-1Bs. Pros for entrepreneurs, quickly. It's a really nice thing to get yourself. So some visas like L's and E's, if you're familiar with them, can be very hard to transfer. I mean, an L is based on your relationship to a company that is doing business in multiple countries. Once you leave that company, you don't really have that relationship with any other company you want to then go join. Same with E's, they're based on investment, they're based on nationality. If the company isn't successful, or even let's just say it's very successful and is acquired, that could terminate your visa. For an H-1B, if you have an approval, if you've been selected in the lottery before and the company is acquired or the company goes under or something like that, you'd have 60 days to transfer your H-1B to some other company, potentially even a new company you started, but you have the ability to move that and kind of be nimble. And that's a really nice thing to get yourself versus having to talk some employer into doing it for you. And again, you can't get it when you need it. You can only get them in the spring. So it's kind of long-term planning. Lastly, it's a dual intent visa. So you can be completing the green card process while on the H-1B. I pretty much covered all of these as I went through them. Again, technical degrees are sort of favored over MBAs. In the Trump era of immigration, that is not always true. Don't let me deter you. Lots of MBAs have H-1Bs. We get them all the time. It's just showing a technical degree can be easier. So even if you have an MBA and an underlying, again, mechanical engineering degree or computer science degree, it might be that that is the one you rely on for your H-1B. And it brings up a point. Let's say you have a, computer science degree from France, but a master's degree from the United States. You could use the master's degree to get yourself into the master's cap, but then still use the French computer science degree as the one that actually qualifies you for the position and the specialty occupation. So again, if you don't have tax returns yet, if you don't have the ability to show a profit yet, bank statements, safes, convertible notes, term sheets are all ways you could potentially show you have the ability to pay the wage. Okay, that's H-1Bs. Let's talk about O's. So I want to stress for everyone that O's are a visa that if you are planning long-term can be something that is attainable. You will read articles about calling them Einstein visas and things like that. They are very subjective. They are not something everyone qualifies for. They can be difficult to get, but you do not have to be Einstein. You do not have to win a Nobel Prize. You just have to meet specific criteria, and meeting those specific criteria can be done in a very strategic, planned way if you have time. Okay, so these should be considered. They are more labor intensive. They do allow for you to complete the green card process at the same time. It's a bit different than the H-1B, how that works, but it does. You can transition to a green card. But let's look at the pros for an entrepreneur. There is no wage requirement under the O-1 visa. There are no equity or employer-employee relationship issues. There is no cap on the number of years. There is no cap on the number of O's per year, so there's no lottery. Okay, so we have plenty of people in Palo Alto earning $1,000 a month, on their O, and otherwise, being compensated through equity, and that is fine. An O does require a U.S. company to petition you, so that you do have to have a U.S. company as the petitioner and you as the beneficiary, but you can be the 100% sole owner of that company, or you can be 0% owner, right? But there is just no issue there surrounding equity. You do not have to have a board of directors that can control your employment or fire you. It's just not an issue. So you do need to have someone from the company that can act as a signatory. Again, that could be a co-founder. It could be a member of the board. It could just be someone you appoint, corporate signatory authority. Again, in counsel with your business lawyer. So there are 8 criteria for an O1, and you need to meet 3 in order to be approved. So I'm going to go through each one, and then I'm going to talk about some ways that you can establish them, or you can collect that evidence over time while you are studying or while you're on some other visa with your current company or something like that. Prizes and awards. Have you won prizes and awards in your field? So there's an Obama era policy that said raising venture capital or angel investments, significant venture capital, is an award. It is an award of capital in your field and can be submitted as O1 evidence. The way the Obama administration did that was they just simply put it on the USCIS website. The Trump administration came along, they deleted it off the website. We still have a copy of it. They still accept it as evidence. They just deleted it off the website. So there's a copy of the page in our book, which is probably worth the cost of the book. But anyways, it does still count. Other examples, 30 under 30 awards, and things like that. And purely academic awards and accomplishments are sort of less favored because USCIS takes the position that they are only open to people at your university. So it's a little less favored. Memberships in distinguished organizations in your field. This is a really entrepreneur-friendly one as well. There are a lot of entrepreneur organizations out there. I don't want to specifically endorse any, but let's just say there are lots of them. I'm sure you all know what many of them are. You can join them, you can qualify. What you're looking for are discernible criteria. So if it says you must be under 40, raised $1 million, and so on and so forth, that's a perfect example of discernible criteria for membership. Other examples, prestigious accelerators, incubators, again, lots of great options there, and they are considered memberships as well. Major media about the alien. This one is harder, I think, to go out and get. It can be hard to just say, hey, I need an article about me in Forbes or TechCrunch or whatever. But if there is media coverage about you, that's really great. And to determine its major, we're basically trying to show the readership or viewership of the website to show that. It does not have to be American media. None of these accomplishments have to be in the US. So if they're in some other country, that is fine. You can simply have the documents translated if necessary and submit that as well. Authorship of scholarly articles or media is the next one. This is sort of, this one favors people with academic backgrounds. So if you have cited publications and journal articles and things like that, that's great. But you can also do things like be a contributing writer. Again, this is an opportunity here to leverage your network, see who you can write for, talk to professors if you're still in school. I think this, unlike media, is very attainable. I know that is in my own professional life too, right? I mean, if you want to publish and write, there are probably opportunities out there to do that. So again, think about where you are expending that energy. Are these places well read? What are their circulation numbers? Things like that. Straight up like blog posts, Medium posts, things like that probably aren't the best evidence. But I mean, if they've been picked up by major sources, major people, things like that, then they could be persuasive. Okay, next, critical or essential capacity in a distinguished organization or a company with a distinguished reputation. So this should be a gimme for every co-founder, right? Because I mean, your role should be pretty critical to the company. So then the real argument is proving that the company is distinguished. Obviously, the earlier stage may be a little more difficult to do. This is a great thing to have investors provide letters of support, professors, other people in your industry familiar with what you're doing, potential customers, actual customers, and also if you have media coverage about the company, this is great. Also, if you have protected intellectual property like patents, that's another great way to do it. Judging the work of others. So pitch competitions, business plan competitions, hackathons. If you have an academic background, peer review is like the textbook example. But any of these can work. Also, if you've worked in venture capital or private equity, I often use evidence of your work there to show that you were judging other companies for investment, making you knowledgeable about starting companies. Next, have you made original contributions of significance to your industry or field? So again, intellectual property is great. I mean, patents are like the textbook example. Patents are also really expensive, so lots of people, don't have them. So you don't have to have a patent, but it's great if you do. They can be pending. And then also letters of support, media coverage, you show success in App Store rankings, things like that. And then, lastly, have you earned high remuneration or compensation compared to others in your field? So that would be basically we look at that DOL wage data, which now is completely skewed and messed up, but nonetheless, we would look at that. We would look at the job you held, and we would compare that to the wage you were earning in that role. So usually not the most entrepreneur friendly if this is not, but it can be. I mean, if you worked in some other field where you were earning, at a high rate and now you're starting a company, then maybe in that previous field, you were earning above your peers. I usually try to show 20 or 30% or greater above peers to meet this one. Again, I think this is probably the least persuasive unless you just blow everyone else out of the water. Because it's just not the most persuasive evidence of accomplishment. You can use equity. It obviously gets more complicated because we need evaluation or we need something to show how that should be calculated. But we do make those arguments regularly that yes, you're taking $45K a year, but your equity is worth blank, and so total compensation is whatever. One more thing on O's. A lot of this evidence comes through letters of support. I usually say 6 to 10 letters of support. If you have lots of other evidence like media coverage and awards and so on, then maybe you only need on that smaller end, maybe 5, 6 letters. If you have less of that, then you're obviously going to need more of that sort of secondary evidence of people saying, no, this really is significant. No, this really was a critical role. No, this really was a lot of money in our industry. Whatever the case may be, co-founders should provide a letter. It's nice to have a letter from one of your investors explaining why they invested in the company. Any organizations you're a part of, that is helpful to have a letter from. And then again, just people familiar with your business. We have a lot of questions. I'm gonna talk about E2 visas for like 2 minutes, just because I want to mention them, but then I'm gonna stop sort of lecturing so we can discuss a little and answer these questions. So E2 visas are based on treaties between the US and 80 something countries. And they say that if you make a substantial investment in a US company, you can have a visa to come operate that company as an investor. However, people from that country can also come work for the company as an employee or a manager or an executive. So both the investor and people working for the company from that country can use the e-visa. The main thing to consider, e-visas are great. They're probably the most like entrepreneurial spirited visas, since they're actually intended for starting new companies. But they require that 50% of the company remain owned by the other country. So it's a Canadian e-visa company as long as 50% or more is Canadian owned. The problem with e-visas for venture funded startups is obviously dilution, right? So if you have Canadian co-founder, American co-founder that each own 50%, and Canadian co-founder does an e-visa today, and then 9 months later, you guys go out and raise a round, and now it's not 50% Canadian, his or her visa goes away with that dilution. So, you know, we do use them, but I tend to use them a lot more for venture funded companies when both co-founders are from the same place. So you have two Argentinian co-founders or two French co-founders or two Mexican co-founders. And so we're starting at 100%, then that makes a lot more sense that, you know, maybe you guys will have green cards or like something else by the time you're below 50% Mexican or French or Argentinian or Canadian owned. But that's the main thing to think about there, I think, and just flags. Like e-visas can be great. There is a dominant thought in the industry that in order to apply for an e-visa, you have to personally put your cash as an investment in the company. That is not true. We use all sorts of investments, including venture capital. We submit safes. We've submitted convertible notes. It's just not true. It's certainly the conventional thought, but you can use many different investment instruments. Okay, that felt like a lot of rambling, so I'm going to read through some of the questions and try and discuss them. So, can founders work from outside of the US due to COVID on post-graduation OPT? Yes. I basically expanded the rules here to deal with remote work due to COVID. Can I move on a B1, B2 visa, so that's a visitor visa, and then change status? So if a person is in the US as a visitor, yes, they can change status to any other status, like an H-1B or an O or an E or an L or any of these employment-based visas. What I will say, though, is that it can bring up an issue of intent. What was your intent at the time you entered? You know, if you are standing at JFK or SFO saying, I'm here to see the Grand Canyon, and then a week later you turn around and file a change of status to E2, that seems like a misrepresentation to me, which is an issue. So if you are here in a B status, then yes, but again, you need to think about what you're using it for at the time you enter the US as well. How does Y Combinator or other accelerators handle international founders from outside of the country? So I won't speak to exactly how YC or anyone handles their internal processes. I can tell you that they have been very supportive in my dealings. They provide letters of support. For O1s, they generally try to introduce founders to, you know, reputable attorneys and things like that. You know, YC sort of has like I don't want to call it template, but they're prepared, I will say, to support international founders on some of these issues. Do you need a college degree to go from O1A to EB1A? So O1A is the O1 category we've been discussing because it includes business. O1B is like entertainment. And EB1A is the green card category for extraordinary ability that sort of mirrors the O1 requirements, but with a bit of a tougher burden placed on it. And the question, do you need a college degree? The answer is no. You do not need a college degree for an O1A or for an EB1A. There are different degree issues that come up with national interest waivers, but that is a separate category. For O1 visa filers using their own company, is there minimum capital requirements for the business? O1 visa business owner self-petition. No, there is not. I do suggest that most people put some money in the bank just to show you can afford to pay yourself the wage, though in all honesty, they often don't even request financials in O1 cases, and there is no requirement really. So no, it's not like the H-1B. Regarding remuneration for O1, would remuneration in your home country as compared to others in that country be considered? I haven't had work X in America. The answer is yes. So you definitely can use your previous work experience and high salary in another country. The only thing it obviously brings up is that we can't then use the US Department of Labor database to compare your salary to. So we do have to find reputable wage surveys or sources in your home country, which I've done in a lot of different countries, and like sometimes isn't that hard. And then sometimes I'm like really deep into some Russian wage survey, so yes, you can totally use it, but you do need to support it with evidence. Another reason for a letter of support from that previous employer, maybe they can discuss how that comp compares to others, but you still do want some other evidence, not just the employer letter. Can you clarify the timing visa requirement between starting a company and applying for an O visa? Sure. So timing, I would say it takes most people 1 to 2 months to put together their evidence for an O visa. That means they have already written those articles or had that media coverage, right? So like, that's why if you're a student now, or if you're working for some other company on an H or an L and you're thinking about doing this down the road, like lay the groundwork now. Try to judge that competition or join that organization or write that article now. Assuming all that's done and we're really just talking about gathering evidence and letters of support, it takes most people 1 to 2 months to do that. Some people do it much faster. Some people do it way slower. Once you give us all of the evidence, which we've obviously helped you get, at our practice, we prepare the petition in 2 weeks. That includes a 20 to 40 page brief about you. So we do pretty beefy petitions where, I write a whole lot about you. So one client said that their O is the nicest thing anyone had ever said about them. And they read it to cheer them up when they were struggling as a founder, since I pretty much just like not humbly brag about you for 30 pages. At that point, we submit to USCIS. With premium processing, you will get an answer in 15 days from them, and that can change your status to O. So, there's basically your portion of the work, and my portion of the work is about 2 weeks, and then USCIS's portion is about 15 days. They can RFE, in which case you'd have to respond, and then they get a fresh 15 days, but it's pretty fast in the immigration landscape. While we are waiting on our OPT, are we allowed to incorporate the company as an LLC before we get the card, or do we need the card? Yes, you can incorporate. And this is sort of the thing I was talking about. Like, incorporation is not the line to make sure you don't cross. The line not to cross is working. Now, I will say, once you've incorporated a company, you are sort of having to prove a negative, right? Like, I'm really not working for this company that I own 100% of and no one else is involved with, yet we're marketing online or something, right? So like, you need to be thoughtful about that process, right? And not work until you have authorization, but actually meeting with the lawyers, incorporating the company, and then, basically just having meetings and setting it aside until you have work authorization is fine. Can you apply for an O1 while on F1? How does O1 transition to green card? Yes, you can. You can file a change of status from F1 to O1. if you wanted, you could continue to study on the O1. How does O1 transition to green card? So green cards really is a whole nother category. It's the second half of the book we wrote. I mean, so it's I'm trying to just give you what I thought would be most useful, but there is a green card category again called EB1A that basically mirrors O1s for people who can establish they're at the top of their field using 3 of the 8, or 3 of the 10 in that context criteria. If you've cited a lot of achievements of your startup for the O visa and the company goes under, does the visa still hold? Is there a quick path to citizenship with O? So to answer the first question, I mean, probably, like the O is transferable. You can transfer your O from one company to another. We do it all the time. I don't think the company going under disqualifies what you did with that company necessarily, right? I mean, if you really, I don't know, got the media coverage, won the awards, raised the capital, those things happen. They're facts and they're not going away just because the company does. So, I mean, I have lots of founders who we are presenting evidence of 3 or 4 of their previous startups in their petitions. And then in terms of citizenship, basically in the employment-based context, you need to go from green card, you need to hold a green card for 5 years, and then you can apply for citizenship. Are there any specific considerations to keep in mind for people with multiple citizenships? Not really. I have 3. The US does not just really acknowledge any of them. I will say, though, that you should consider the laws in your home country or countries of citizenship. Some other countries don't allow for dual citizenship. So just be aware of that before applying for US citizenship. For e-visas, what is the investment amount required? So there is no required amount. People will say $100,000, even though it clearly is not the rule. The rule is that the investment amount be substantial in proportion to the cost of the business. So if you're starting a $100 million manufacturing plant, $100,000 is probably not substantial. It is not. If you are starting a tech company where you're just going to buy some computer equipment and pay some salaries, then $100,000 is probably quite substantial. I usually look at what are the first year of expenses and try to encourage people to have enough capital to cover that. So you have to submit a 5-year business plan. So if year 1 shows you're going to have $130,000 in expenses, I suggest having up to $130,000 in investment. They are harder with lower investment amounts, particularly in certain countries, right? So, I mean, London is going to look at your $100,000 probably different than, I don't know, a country where the currency is worth less than the British pound. So something to think about. My friend is in the US on an H-1B visa, intends to start a non-tech company with me while I am sitting in India. So that would be the best. What would be the best way for me to come together in the US and start working? We should probably just discuss your options one-on-one because there could be a whole range of them. Unfortunately, there are no e-visas for India. Notably, there's also not for Brazil, Russia, or China, pretty large countries. But maybe the O is an option. Certainly working from abroad for now is an option. Maybe you incorporate there and then come on an L once you've worked abroad for a year. A topic I didn't cover, but I'm happy to discuss with you. Pair has partnered with many international founders because they're awesome and help them to obtain visas. Is a non-US bachelor's engineering degree sufficient for H-1B? Yes, it is. Foreign degrees are acceptable. They just need to be equivalent. So we can get an equivalency to make sure, generally you just want to see 4 years of credited college. For O visas, can you count achievements, publications during previous career if not necessarily well linked? That is an interesting question. And the short answer is you should create a narrative that connects the dots between all of your accomplishments. So, you should come up with a way of explaining how those previous accomplishments somehow helped you in this one, so you sort of get credit for the work that you've previously done. That's an overarching part of the O1 strategy and should really, really be a part of it. Is there a time limit on the percentage of international? Is there a limit on the percentage of international students working for a startup under an O? No, there is not. There could be 3 or 4 co-founders all on O1s. I don't know that I've had that many, but I have lots of companies where there are two co-founders and they're both on O's, and we did them both. And they signed each other's O's, right? Because they're co-CEOs or co-founders or whatever, or CEO and COO. Can an employee working full-time with a company on an H1 or L1 register a startup outside of the US and operate as an overseas worker while living in the US? Actually, no. Some people may disagree, but the conservative answer there is no. If you're physically in the US working for a company, you should have work authorization to work for that company. Is the founder H1B, does the founder H1B come under the lottery system? I think what you're asking is, as a founder, do you still have to go through the lottery? And the answer is yes, if you haven't previously been counted. So if you were at some US company and they counted you against the cap, they got you selected, then you don't have to go through lottery again. You would just transfer that H1B to your company. If at some point, Ian, you need to tell me to stop answering questions, that's
I was just about to ask Jason. I'm very conscious of your time as well, so
I can keep answering them. It's totally up to you.
Well, maybe probably can't take that many more questions. I understand. I mean, very mindful of your time, but maybe if you make your way through a few more, if you'd be willing.
Sure, no problem. Thanks for all of the questions so far, none of which have been about, Pennsylvania suburbs or anything like that. How about, so the difference between O1A and O1B is that O1A includes business and O1B is for basically people in entertainment and the arts, so it shouldn't really apply to anyone here. So this question comes up a lot, incorporating while working at a tech company like an Amazon. Again, incorporating is not the issue. The issue is working. So if you're working at Amazon on an H1B or something like that, and you incorporate a company to then work on your new startup, you should probably file a concurrent H1B. So another H1B with your company. So now you have authorization to work at both jobs. I'll look at one or two more. Someone asked about hiring interns. You can look at J1s. There's a specific category of J1 visas for interns. Maybe that's a good place to stop. So if I'm the founder under OPT of my own company, do I need to put myself under wage and report this to CVIS? After getting the EAD reported I was working for my company, do I need to do anything else from my side? So let me just say, I know the most people want to not take a salary for obvious reasons with their new company. But if you're on OPT, you probably should take a small salary. And my reason why is if you're on OPT, you get 90 days of unemployment. And if you have more than 90 days of unemployment, you lose your OPT. So the easiest way to show that you are employed is your paychecks. It is actually the way USCIS will RFE you for that information. And if you haven't been taking a salary, it can be really difficult to prove you've really been working. So again, I suggest you take a small salary, report that wage to CVIS, and take those paychecks so you have a nice record that you've been employed and working the whole time. So I'll stop with the questions. If you have any more, my email's there. And then also, if you're interested, send me an email with your name and address, and we'll send a copy of the book to the first 50 people who respond. And I promise we're not going to use your contact for anything else or anything like that.
Thank you all who joined today, and hugely thank you, Jason. I mean, it's been a real fountain of wisdom listening to this talk. I really appreciate it. And I mean, hearing it from the person who literally wrote the book on this topic has been great. I'll follow up to everyone who attended as well with a quick email. And yeah, thank you all who joined today. Thanks.
Thanks so much, Ian. Thanks, everyone.